Many people don't realize some inventions cannot be protected with a patent, no matter how brilliant they are. And if you don't know the difference, you can waste years and thousands of dollars chasing a dead end. Let me save you from that mistake. When people come to me with their invention, their first question is, can I patent this? But the better first question is this the type of thing that could be patented at all? Because not every idea qualifies. So today, I'm breaking it down. Which ideas can't be patented, why they fail, and what to do if your idea falls into one of these traps. So what cannot be patented? Number one, abstract ideas. This is the classic concept trap. Just having a raw idea isn't enough. You can't patent a raw concept without a real concrete solution. Another way of looking at this is that the need doesn't get protected. It's the solution that gets patented. As an example, an idea for a better way to organize your schedule is just an abstract idea, unless you've designed a physical product or a unique software process that makes it real. The lesson is, the Patent Office grants patents for practical solutions, not for vague concepts. Number two, natural phenomena, because nature isn't patentable. You can't patent discoveries of natural things, like a new plant, a mineral, or a naturally occurring DNA sequence. As examples, you can't patent water, gravity, or photosynthesis, but you can patent a man-made process that harnesses them in a novel way. You can patent generating energy from waves, but you can patent a machine that you invent that harnesses the power of waves and converts it into electrical energy. The lesson is, you can use nature, you just can't own it. 3. Laws of nature and scientific principles. You remember the formula E equals mc squared? No one owns E equals mc squared, because that formula, discovered by Einstein, reflects the natural relationship between energy and matter. You can't patent one of the laws of physics or a mathematical formula by itself. Remember the Pythagorean theorem from high school? A squared plus b squared equals c squared. The way that you can figure out one of the sides of a right triangle from the other two? You can't patent that. You can't patent the Pythagorean theorem. But if you patent a product that uses it in a new mechanical way, that new application or that new solution may be patentable. The lesson is, the principle itself is off limits for patent protection, but its unique use case might not be. Number 4, purely mental processes or ideas, because thoughts don't count. If your invention happens entirely in the human mind, it's not patentable. As an example, a new way to meditate can't be protected. But if you invent a meditation device or app with unique functionality and a unique process, now you're in business. And the lesson here is, ideas need a tangible expression. Number 5, non-functional aesthetic designs, not suitable for a utility patent. If your innovation is purely about the way the product looks and not any functional aspect, it may fall under copyright or trade dress or even a design patent, but it's not suitable for a utility patent filing. As an example, a new graphic design pattern might be copyrightable, and a unique product shape may be protected by a design patent. But don't file a utility patent for this because it won't work. And the lesson here is, form without function isn't enough for a utility patent. This is a common mistake. I have an idea, let's patent it. Many beginners rush to file a patent application just because they think they have a great idea. But without a concrete functional solution, the patent office will probably say no. And now that's not to say that you actually need a prototype to file a patent application, because you don't. But your invention needs to be a solution, not just a raw idea. I've seen inventors spend thousands on applications that never stood a chance, because it just wasn't the right thing that could be patented. Even if it was unique, it was the wrong thing to apply for a patent. If you're unsure whether your idea qualifies, that's where a patentability evaluation comes in. It's better to find out early, before you invest in filing fees, prototypes, or legal costs. Many patent attorneys will happily take your money, even if your idea has no shot. You need someone who will tell you the truth up front. That's why for more than 30 years, I've specialized in working with new inventors and entrepreneurs, helping them navigate these early decisions in the right way. If you want to find out if your invention's patentable, book a free strategy call. The link is in the description. What's stopping you from moving forward with your invention? Drop it in the comments so I can make a video in the future to mitigate your concerns. But please don't put any confidential information, and especially don't tell us about your idea in the comments. Next up, I'm walking you through how to do a patent search on your own, step by step. It's the first thing every inventor should know, and I'm going to walk you through it.